Thanks for listening to Reasonable Doubt on Podcast One.
RockAuto.com. Why spend 30 to 50%, even 100% more for the same parts that a chain store or dealership might have? Why spend so much there? Why not go to RockAuto.com? It's a family business serving auto parts customers online for 20 years. Go to RockAuto.com to shop for auto and body parts from hundreds of manufacturers, everything from engine control modules to brakes to motor oil, even new carpet. Whether it's for your classic car or your daily driver, get everything you need in a few clicks delivered direct to your door. Go to rockauto.com, see all the parts available for your car or your truck. Write doubt in the How Did You Hear About Us box so they know we sent you. An amazing selection, reliably low prices, all the parts your car will ever need. RockAuto.com.
Streaming only on Peacock, a new original comedy.
Me, in a punk band?
We Are Lady Parts.
A confused mix of hash anthems and sour girl power.
You puked all over the front row. Ew.
We Are Lady Parts. All episodes streaming now, only on Peacock.
This is Reasonable Doubt with your hosts, Mark Garrigus and Adam Carolla.
Welcome to this bonus episode of Beyond a Reasonable Doubt. By the way, we just started it this week already. We're doing incredible numbers of listeners, and the reaction has been great. So Gary and I have decided we're going to lean into this, right, Gary?
Absolutely, and we're going to continue recording this both as a podcast and as a video offering. But I think that starting next week, Beyond a Reasonable Doubt is only going to be available to consume on video on the Reasonable Doubt YouTube channel. We're not going to put it on Adam, so go subscribe, youtube.com/Reasonable Doubt Podcast.
Fantastic. So you're going to give us an update as to what happened in the trial since Tuesday?
Yeah.
Why don't you give me the highlights and I can talk about it, because there is talk about an embarrassment of prosecution riches.
There's been no shortage of news, that's for sure. These are supposed to be mini episodes, but this could easily be a full hour. Let's start with Special Agent Ryerson, who was on the stand, and upon cross-examination, the defense attorney played a video that was brand new to me. I had never seen before, where it's part of the time that George Floyd is on the ground, and in the video, it sounds like he says, I ate too many drugs. And Originally, the defense attorney plays it for the special agent and says, did you hear that? And does it sound like he in fact said, I ate too many drugs? And Special Agent Ryerson said, yes, I did hear that, and that is what it sounded like. And then they took a break, and then he came back and he changed his mind and said, I think he says, I ain't do no drugs.
Right. And by the way it actually unfolded is emblematic of what happens in many trials. You ask somebody when you're cross-examining somebody and they don't know where you're headed, and you say, doesn't it sound, this is what Eric did, Nelson, the defense lawyer, doesn't it sound like he said, I ate too many drugs? And he said, yes. Then the prosecution gets back up and they say, well, in context, doesn't it sound like he said, I ain't doing too many drugs, or I ain't doing drugs? And he says, yeah, in context. Well, look, people were focusing on that. There's two comments I have. Number one, if those are two reasonable interpretations, by the way, the tie goes to the defense. An interpretation that points towards innocence, one that points towards guilt, you have to adopt the one that points towards innocence, which goes to the defendant. Number two, if it was, I ain't doing any drugs, or I ain't did any drugs, well, then, and this will probably lead into the next point you're going to make. One of the other things in context is the defense asked the judge for the ability to go do an inspection, their own independent inspection of the police car. The police car was impounded right after the incident. So we know that, or at least presumably, if you believe the prosecution, nobody's been in that car since. Well, when they cut the seal and they open it up, what do they find? They find pills that they analyze and have George Floyd's what's called saliva amylase on, which is basically like a DNA signature. Now, the unbelievable part is that when this is brought out, the prosecution then says to the person who's on the scene, basically suggests that the defense had planted the drugs. That was the implication. So the defense gets back up and says, did I ever enter the car? No. Didn't you cut the seal on the car? Yes. You were the one who went in there and discovered it, right? Yes. So the whole prosecution trying to slime or smear the defense backfired in their face. And now when you're playing the tape about, I ain't going to do the drugs, the prosecution's interpretation, well, what are you trying to do? Talk about sliming people. You are now basically calling your victim a liar. So I don't know how that helps. And I think it's an extremely bad misstep and was not a good day for the prosecution.
Another in the list of things that were not great looks for the prosecution. They had the ER doc, Dr. Langerfield, on the stand, and they had him testify that Floyd died of hypoxia. And the defense immediately got up and said, well, would meth and fentanyl cause hypoxia? Yes.
Yeah, exactly. And the once again, I'm going to say the same thing because I need to caveat this or bookmark it because people don't. I sue cops for a living. I am somebody who believes cops should be held accountable. At the same time, when you're in a criminal trial, you need to call it like you see it, and you need to hold people and prosecutors accountable. This is not trying the victim. For anybody who says that, you don't know what's happening. What this is one of the main elements of the crime is, did your act, meaning did Chauvin's act, was that the proximate cause? Was that the causation? Is that what caused the death? If the meth and fentanyl combination was a reasonable explanation for the death, that would negate the element in a murder or manslaughter charge. So please stop with the trying the victim. They're not trying the victim. And understand what's happening, because you tend to mislead people when not you, Gary, but others do in the reporting on this.
Yeah, the reporting has been irresponsible to say the least, I would say, but that's why we're leaning in here. So a state witness, an expert state witness, said he reviewed the case files and the videos and said that the death was from a low level of oxygen that was caused to being in the prone position and handcuffed with a knee on the neck and back. Now that part's interesting because they also had a police chief up on the stand who agreed that in certain portions of the video, it appeared that the knee was on the back and not solely on the neck. So that was a bit of an interesting development as well.
Right. And, one of the things that just kills me in terms of the irony of this is the fact that the prosecution is using a use of force expert who's from LAPD. And for those of us who have lived under the yoke of LAPD for decades, the irony is not lost on us. Number one, you're talking about the department who brought you Rodney King. Number two, this was not a shining hour for the prosecution in terms of their expert witness. It just wasn't any way you cut it.
Yeah, and in fact, I think they had two expert witnesses in the past couple of days, one of which it was, I think, determined during cross that it was the first trial they've ever participated in.
I think that was the LAPD expert.
Yeah,
I could be wrong, but
I think you're right. I think you're right. Yeah. That's just,
and that's what you do. I mean, you literally have an unlimited budget in order to prosecute somebody, and you go to LAPD and bring somebody in who's never testified as an expert before. It's astonishing to me. I don't know what they're doing. I've said this case last week was all about feelings, which didn't address the elements of the crime. And this week, the prosecution has basically tried to mislead the jury and has been caught not once, not twice, but at least 3 times on significant issues.
Right.
And that's not a good look. I mean, it really isn't.
And that particular expert is one of those times that they've been caught, because that expert basically got on the stand and tried to lay out that the use of force doctrine is based on a standard in a case Graham v. Connor, and that it came down to 3 bullet points. And the defense promptly got up there and explained and got the expert to admit that in fact it is more the totality of all the elements of the interaction, and not broken down to those specific 3 bullet points the way they wanted to fit it in.
And you might remember last episode, a couple of days ago, I said that one of the things the defense did, and people didn't understand at the time, he was reading from that U.S. Supreme Court case to the chief of police, because he was establishing with the chief of police that his decision was an employment decision, and was not, don't confuse an employment decision with what the jury's decision is on a criminal case. Then he tied that in here by once again bringing up the 3 bullet points from the U.S. Supreme Court law. So there is a method to the madness, and people who don't understand that may be surprised later on.
Yeah, absolutely. Would you say, Mark, that so far the defense has been running a more textbook game plan based on what's actually happening in the courtroom, whereas the prosecution is leaning more on a court of public opinion?
Yeah, I think that's a perfect way to put it. What's happened is the defense is playing to what they're supposed to do with a jury, because I understand that people, and I'm amongst them. Nothing is more cathartic than listening to people talk about how it affects you. I mean, that's what you do in a civil case when you're talking about distress and damages and things of that nature. But the witnesses are, they may be victims in the non-legal sense of the word, but for purposes of the elements of the crime, they're not the purported victim. That is a sentencing, could be potentially a sentencing factor, but that isn't relevant at this point. And I know that the prosecution wanted to lead, and I've been horrified by the commentary on some of the channels of this trial so far, literally horrified that seemingly self-identified or self-proclaimed criminal defense lawyers are making statements that would seem to ignore due process, would seem to ignore the presumption of innocence. And no matter how much you despise the defendant, I don't care if it's, and by the way, I've defended the most hated man in America, 1, 2, and 3. Just because you despise the defendant does not mean you dispense with things, those nettlesome things called due process and the right or presumption of innocence. And by the way, you're starting to see a judge who is getting somewhat, if you watch prolonged periods of time, is getting somewhat frustrated by some of the things that are happening in his courtroom. I mean, that's a subtext that we haven't talked about, and I haven't seen reported on at all. Yeah, that's become apparent, and you're right. I've been getting that feeling as well, and really watching the trial is kind of the only way to distill any information that is pure. To watch any of the commentary is, I agree, it's a bit horrifying. I watched a couple of segments both on MSNBC, CNN, and Fox. I watched those. Then I scrolled up to, I believe it was C-SPAN 2 or wherever they're streaming it. It's astonishing to me to watch what actually happens versus what's been reported. And I think that does an enormous disservice to the public, because be even-handed. I will admit, I read, and I wish I had the author's name on the tip of my tongue. I read a Washington Post article and also buried in the bottom of an NBC News article where they had given some, I thought, at least a perspective that took into effect that a journalist is not supposed to be a cheerleader for the prosecution. And this is just reminiscent of kind of that early 90s, early 2000s, when the journalism was a cheerleader for the prosecution, except back then it was completely inverted in terms of who was being hoisted on the prosecutorial petard. Absolutely.
All right. I think one more thing that we'll finish up on. There's been some developments. I don't think we covered in detail on Maurice Hall, the passenger.
I think we leave off of that because that may be the next episode tomorrow when Adam's back.
Hopefully, yeah. The Saturday episode, which we record on Fridays. So Maurice Hall was the passenger in George Floyd's car when the interaction first occurred. He has been speculated to be George Floyd's drug dealer. He has a criminal history, is currently in jail on unrelated charges, and he, through his lawyer, has stated and asked the court to not call him as a witness because he has stated that he will be taking the fifth if he is brought up there. He is understandably worried that this will turn into a charge for him. I have seen speculation that he believes he might get a murder charge if, the speculation being that if he did give him the drugs and it is somehow proven that the drugs played a role, that could be a real problem for him. So the judge has ordered the judge has ordered the prosecution to try to tailor some questions in such a way that he would be able to answer without taking the fifth. And the impression that I am getting from the statements from Maurice's attorney is that that's just not going to happen, especially given the reported questions that she wants to ask, which are, did you give him drugs? Did you know about the fake $20 bill? And why did you leave the state of Minnesota after his death? So, well,
this is once again, I haven't seen it, anybody getting up and calling it like they should. Understand something here. In rare instances, a judge can confer immunity. However, that road to a judge conferring immunity leads through the prosecution. The prosecution could solve this problem. If they were interested in getting to the truth of this case, they can wave their magic wand, give Mr. Hall, it's Hall, correct?
Yes.
They can give him immunity from prosecution in trade for his truthful testimony.
Now, let me ask.
The defense can't do that.
Let me ask, can they grant him that federally as well? Because we've speculated.
No, they can't. They cannot grant him that federally. However, as a practical matter, there is a doctrine whereby if he testifies, if the feds tried to come in later on and prosecute him, because in most states, and I don't know about Minnesota, I know in California, it's now allowed where you can doubly prosecute, so to speak. Somebody can be given immunity or be acquitted or convicted in state court, and they can come pile on a la Rodney King in federal court and do it again. But there is a process by which the feds would have to say, we never considered anything that was testified to when we made this decision. So the prosecution could grant immunity, and then it would be up to Hall's lawyer to raise what you just raised. But you notice the prosecution is not granting immunity. And so whenever they want to seize the moral high ground about they're just seeking the truth, then just ask yourself, why aren't they granting Maurice Hall immunity? Let him testify.
Yeah.
And let him have no fear.
So the judge gave the prosecution until today to tailor those questions and submit them. We checked the court's website, the online docket, right before we started this, and they have not been revealed yet. But as you alluded to earlier, we will be recording this Saturday's full-length Best Hour in the Universe tomorrow with one Adam Carolla, and we are very hopeful and optimistic that we will have those questions by then, and hopefully we can get some analysis out of Mark as to whether or not this gentleman would take the stand. I'm going to say no chance, but that's just me.
Well, my guess is the judge ordered the defense to tailor the questions because they're the ones who want him, and that the prosecution, because he could tell the prosecution or order the prosecution to seriously consider giving him immunity, and that would be the precursor to the defense. If the prosecution refuses to grant immunity, then the defense would have the ability to go to the judge and say, we're being deprived of a substantial right here. You need to step in and grant judicial immunity.
You are exactly right. I am not used to following my notes while co-hosting. It does say that Nelson was directed to tailor the questions. So
it would make sense because the judge knows that the prosecution could confer immunity, and this would not be an issue. And all that the prosecution is doing is, it's gamesmanship, because if they want the truth, grant immunity, let him testify.
I think we'll leave it at that. Tune in on Saturday for the best hour in the universe, the regular Reasonable Doubt, and we'll keep doing these Beyonds probably on Tuesdays and Thursdays, so stay tuned for those. And Mark, thank you.
Beyond, and not vegan Beyond. Yeah.
Bye-bye.
Thanks for listening to Reasonable Doubt. Tune in next Saturday for an all-new episode.
Mohammed from Williamsville started at Geico in 2007. 10 promotions later, he's a high-level manager in the claims department.
When I first came to Geico, I thought to myself, just a job, and I'll look for my career in my business management. And then I just kept getting promoted one after another, and I just realized that this could be my career. And obviously it is. There's a pretty good map on how to become a supervisor, on how to become a manager, on how to become whatever you would like to become.
Apply online at geico.jobs/Buffalo.